Assalamu alaikum and a very warm welcome to all, especially to our chief guest, Advocate Rashmi Singh Sahiba. No woman in the history of independent India has fought a long and more courageous battle for justice for Bilkis. During the Gujarat pogrom of 2002, Bilkis was criminally assaulted by 11 men. Her 4-year-old child killed besides her mother and sister. Yet she did not surrender to her circumstances and fought for justice after hearings in Session Court, High Court and Supreme Court. The 11 criminals were awarded life imprisonment. Unfortunately, on 15th August last year, they got their freedom for jail as Gujarat government released them. A BJP MLA even called them sanskari. Bilkis resumed her battle to send them back to jail. Last Sunday, the men surrendered at a police station at Godhra. It's possible by the likes of brave and selfless Advocate Rashmi Singh Sahiba. At a time when speaking against the government is getting increasingly difficult, Rashmi braved the odds by fighting for Bilkis, who virtually had the ruling party, the machinery, ranged against her. We are fortunate today to have amongst us Advocate Rashmi Singh herself. She will tell us how she, along with others, Shobha Gupta, Vrinda Grover, and etc., got justice for Bilkis. All over again. Over to Advocate Rashmi Singh Sahiba. Thank you.
So, I would like to begin by first thanking you for giving me this opportunity of talking about a very remarkable woman, an extraordinary woman, a beacon of hope and inspiration for all of us, Bilkis Bano. Now, before I get into the details of her case, we need to understand that under the Indian Penal Code, murder and gang rape are the highest degrees of crimes. And unfortunately, in Bilkis's case, both these offences were committed in the most grotesque and diabolical manner, driven by pure communal hatred. The fight that Bilkis endured at every level, had to approach the court even to get basic things done, which the system should have assisted her with, is something that I will talk about. To understand that, first let's just understand what is the standard criminal machinery. So anytime a cognizable offence, a serious offence is committed, the police will register an FIR at the behest of either the informant or the victim. This is a mandatory exercise that the police must do. Once the FIR is registered, the arrest is effected, and then within 90 days, the charge sheet is filed. Now, in Bilkis's case, the FIR was registered on the 4th of March 2002, and eventually the police filed a closure report citing the reason that they couldn't trace the accused. And this closure report was eventually accepted by the judicial magistrate in 2003. So it took around a year, and ultimately they accepted the closure report. This was the first time that Bilkis had to approach the Supreme Court. And when she did, she asked for the cancellation of this closure report. She did this with the assistance of the NHRC, which is the National Human Rights Commission. The Supreme Court was pleased to entertain this petition, and they directed reopening of the investigation, and the matter was transferred to CBI. This was her first hurdle. Then the CBI reopened the case. In 2004, a fresh charge sheet was filed by CBI. And then again, Bilkis had to approach the Supreme Court, this time for shifting of the trial from Gujarat to a neutral place, because she was afraid that, the witnesses, etc. would be influenced. Again, thankfully, the Supreme Court entertained this petition as well, and the trial was transferred from Gujarat to Maharashtra. And Sessions Court in Bombay took cognizance and the trial commenced. Now, just to understand how this case became what it did, certain nitty-gritties which might not, which might be slightly disturbing, but I would like to point them out anyway. I'm just starting with a note of caution. So, when the trial court's judgment came out, the prosecution's submissions were recorded, and the prosecution had pointed out certain lapses in the investigation, all steps. So I'll just read 3 of them out. The accused police officials. So 12 men were accused of gang rape and murder. 2 doctors were accused of trying to make evidence disappear so as to protect the accused. And 6 police officials were accused. So far as the police officials and the doctors go, this is what was submitted by the prosecution before the trial court. 1. The accused police officials visited the spot where the dead bodies of Bilkis's relatives were lying on the 4th of March. They took photographs of the dead bodies without carrying any inquest panchnama which is required under law. Inquest panchnama basically is a formality which is a mandatory formality when the police officers visit a spot where a dead body is found. They are supposed to make entries of details of condition of the dead body, the person, clothes, etc., belongings that were found on the spot. That was not done by them. They left the dead bodies unguarded. Then later they framed an inquest which had false statements in it. Statements such as, for example, Bilkis's daughter's body wasn't found. Similarly, the doctors, they recorded false statements in the post-mortem. They didn't even collect the biological samples that they were supposed to, like blood or, vaginal swabs, etc. The accused police officials also caused the evidence of the crime to disappear by burying the bodies in a pit with common salt without collecting blood or other biological samples. So all of this, and again, this is the submission of the prosecution, not a finding of the trial court. So all of this was done as per the prosecution to save the accused, to make the evidence disappear. And hence they filed a closure report saying that, well, we didn't get anything. The trial court's judgment then came in 2008. The trial court found all 11 convicts guilty of gang rape and multiple murders. But the trial court acquitted the doctors and the police officials, citing insufficient evidence. So this trial court judgment in 2008 was challenged by the convicts, of course, against the conviction, but also by the state against the acquittal of the doctors and the police officials. So when the High Court passed its order, it upheld the conviction, but it also convicted the doctors and the police officials, saying that there was a serious lapse in the investigation. I would like to read a line from the High Court judgment which sort of sums up these lapses. The truth and falsehood are mixed up in such a manner that at every stage of the investigation, the truth is hidden under layers of intentional laxity, omissions, contradictions, and falsehood, and the truth is required to be unearthed. So this was a High Court judgment that was passed in 2017. Again, it was challenged in the Supreme Court by the convicts, but those SLPs were dismissed. So with this, the first round got over, and all the convicts landed up in jail. And there was, for a few years, justice was served. Then, moving on, why we are here today is because a judgment was passed in January of 2024, this month, cancelling the remission granted to these 11 convicts. it's very important now to understand what remission means. Remission is not pardon. Remission does not take away a person's conviction, does not forgive him, basically. Remission is just a reduction of sentence. It's a discretion of the appropriate government. So it's important to first understand what remission means. Now, remission is not pardon. It does not mean that a person's conviction is taken away. It only means that a person doesn't have to suffer the entirety of his punishment. And the appropriate government has the discretion to grant remission. It's normally granted in consultation with the opinion of the presiding judge who did award the conviction. This might get a little technical, but just, bear with me. So, 2 sections of the Criminal Procedure Code, that is 432 and 433A, they deal with remission. This is important because that's basically why the entire legal battle was fought here. So 432 says that the appropriate government has the power to grant remission, and it can take the opinion of the presiding judge. Importantly, and you can make a mental note of this, the appropriate government, as per section 432, is the government of the state where the trial takes place. So in this case, because the trial was transferred from Gujarat to Maharashtra, that is why the Maharashtra government was the appropriate government. This is a very important point. 433A says that in case of life imprisonment, a person has to undergo 14 years of imprisonment, and only then the person is eligible to apply for remission, not before that. Other offences you can apply whenever. So again, a person doesn't have a right to remission, but a person has a right to apply for remission. It's up to the government whether they want to grant it or not. Now we come back to the facts of this case. So, after undergoing 14 years, 5 months and 6 days of his sentence, one of the convicts named Radhesham Shah applied for remission. This is in the year 2019. He approached the Gujarat High Court and he sought premature release. He sought consideration of his application for premature release. Gujarat High Court said that, well, Maharashtra is the appropriate government, you please apply before Maharashtra. So then he went to Maharashtra, he applied there. 1st August 2019 was his application. And he was given a negative opinion by all the authorities involved in the process. To give you a rough idea, those authorities included the CBI, the Special CBI Court, the SP Dahod, the Collector and District Magistrate, and all these negative opinions were given in view of the fact that the offence was very serious and heinous, and therefore this person was not eligible for premature release. Thereafter, the convict again, Radhesham, again approached Gujarat High Court, and on 13th of March 2020, again the Gujarat High Court said that, well, you go to the Maharashtra government, we can't really do anything about your remission. When all of this was happening, a committee was constituted. The Jail Advisory Committee was constituted, and it held its meeting on the 20th of July 2021. Now, what's a Jail Advisory Committee? It basically consists of social workers, members of Legislative Assembly. It consists of the Superintendent of Police, in this case Superintendent of Police Godhra, Sessions Judge Godhra, SP etc., DM, and they together sit and decide whether a person who's applied for remission is eligible for it or not. This opinion of the JAC, let's call it JAC, is then sent to the Additional Director General of Police Prisons, who then sends it to the Chief Secretary, etc., and the process goes on. So the JAC then in 2021 gave a positive opinion for the first time that he is eligible for premature release. Although it's interesting to note that even in this, the Sessions Judge Godhra gave a negative opinion, saying that it's a very heinous crime. So all of this was happening. I don't want to make it too technical, so I'll to give you an idea that this a sudden twist had basically happened. That till now it was all negative, but suddenly a positive opinion appeared out of nowhere. Now in all of this, Radhe Shyam, the convict, he approached the Supreme Court. Now, normally, when you want to challenge an order of the High Court, there is a process called filing of the special leave petition. That's how you challenge an order of the High Court in the Supreme Court. To directly approach the Supreme Court, you go under Article 32, which is a writ petition. So he filed a writ petition under Article 32. He didn't challenge the orders of the High Court that had denied him remission. So he approached the Supreme Court. He suppressed certain very material facts. He did not disclose that earlier the High Court had dismissed his petition, etc. And he got an order from the Supreme Court. Basically, he was seeking that my premature release be considered by the state of Gujarat under a policy dated 1992, where he was eligible for premature release. And this order he got. 13th May 2022, Supreme Court allowed his application to be considered. So, following this order, the proceedings ensued. Not just for Radhe Shyam, but for other convicts also. And ultimately on 10th August 2022, all of them were granted remission, which was in the news. And the outrage that this created, we are all well aware of that. It was as a result of this outrage, in fact, that public interest litigations came to be filed in the Supreme Court. Because this went to the very, it hit the conscience of the society at large. It went beyond all legal precedent, because normally in criminal cases, it is the victim who has the locus to file petitions. Well, a lot of PILs were filed, and eventually even Bilkis had to knock the doors of the Supreme Court again, and she also approached the Supreme Court. The judgment that finally came to be passed on the 8th of January by a bench of Justice Nagaratna and Justice Bhuya will always be remembered as an example when the Supreme Court fulfilled its duty to protect our rights to uphold the rule of law. It's a landmark judgment, and it's a lengthy judgment. I can't really cover it, so I have only extracted the key conclusions of that judgment. Before I get into that, though, the contention before the Supreme Court in this round, which is the final round in which all of us were involved, the contention was that the grant of remission was wrong because the state of Gujarat was not the appropriate government, could not have been the appropriate government under 432 CRPC, and also under the law laid down by the Supreme Court in a judgment called the Union of India versus Sriharan. So, on mainly these two points, this was raised that you have to quash these remission orders. Of course, the point of the crime being a heinous one, etc. These contentions were raised, but ultimately, these are not grounds that you can, really rely on to get a remission cancelled. It has to be a legal flaw, and the legal flaw was that state of Gujarat did not have the jurisdiction to grant the remission at all from the get-go. So, after hearing detailed arguments of both the sides, three main conclusions of the Supreme Court were: one, that the state of Gujarat did not have the jurisdiction to grant remission. So its orders were illegal and hence they were quashed, the remission orders. Two, that the Supreme Court order, which is the 13th May 2022 order, which was the very beginning of this whole process, that order was obtained by the convicts by resorting to suppression and fraud. And there's a principle in law that fraud vitiates all. So anything that is obtained fraudulently will be void ab initio, which means it will be a nullity from the very beginning. This was the second conclusion. And the third conclusion was that the state of Gujarat had usurped the power of the state of Maharashtra. Because in all fairness, it was the duty of the state of Gujarat to have raised this objection, and this has also been recorded in the judgment, that they should have challenged the 13th May 2022 order and they should have brought the correct position of law before the court, but they chose to not do that. So hence, the doctrine of usurpation of power was applied by the court, and it was held that the government of Gujarat did not have jurisdiction. So these were the main conclusions, but what I feel is the most remarkable feature of this judgment, something that none of us were, all of us were of course hoping, but it's unheard of, was to send back people who are out, who are enjoying their personal liberty, to send them back to jail. It was done by the court, and of course we laud the Supreme Court for doing that. But while dealing with this very difficult question of taking away a person's liberty, liberty is the most sacred thing. It is everything. If you don't have liberty, you don't have anything. It's protected by our fundamental rights, Article 21. It's one of the most sacred fundamental rights. So always a lot of hesitation, a lot of restraint is exercised whenever liberty is taken away. So while dealing with this difficult question, a very significant observation was made by the court. And the court said that the rule of law cannot surrender to liberty that is earned as a consequence of its breach. Which means that when you have obtained your liberty by defrauding the court, by suppressing material facts, by exercising authority that wasn't yours to be exercised, then this liberty is not protected. It's not protected under the Constitution. It is a breach of the rule of law. And hence it's taken away. So in view of this observation, the convicts were directed to surrender back, report back to their concerned jail. They in fact applied for an extension of time to surrender later, and that too was denied by the court. And I think on the 21st, all of them surrendered. Bilkis's legal battle has been a long but very successful one. She was fortunate to have a good support system, to get the legal aid and counsel of Ms. Shobha Gupta, who were there to assist her throughout the way. And I feel that Bilkis must always be remembered not as a victim, but as a survivor. She must be remembered for her perseverance and her ability to overcome the most difficult obstacles that life threw her way. She emerged victorious not because of the system, but despite of it. Bilkis's victory restores and strongly affirms our faith in the Supreme Court as an institution of justice and a guardian of our Constitution. Now I would like to conclude my speech, but deviating slightly from the topic. Rape is something that I just wanted to talk in a line about. Rape and gang rape cause not just physical injury, but also leave mental scars which are permanent in nature. And it becomes very crucial for people surrounding the rape victim to not treat them as having lost a sense of purity about them. The taboo needs to be eradicated completely, and we must, all of us, treat rape victims with dignity and respect. They deserve it. That's all. Thank you.